Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States in this honorable court.
Thank you, and welcome everyone. I think you're probably very familiar with how this works now, but please remember to mute yourself when you're not up, but to unmute yourself when it is time for you to make your argument. Also, please recall, do not photograph or record video or audio this session. As well, when you make an argument and tell us something about the record, a record cite is really helpful because my colleagues have memorized the record, but I have not. So that would be much appreciated. And please also recall that rebuttal is for rebuttal only. So with that, we will begin with case number 20-50203, United States versus Haggerty, and we'll begin with Mr. Newton.
Good morning. May it please the court. This case ultimately is about the government's burden to prove that federal jurisdiction exists. The specific issue is whether a defendant's non-Indian status under Section 1152 is an element or instead is an affirmative defense. However, because proof of a defendant's non-Indian status is necessary to establish federal jurisdiction over the underlying offense of malicious destruction of property owned by an Indian tribe in Indian country, the defendant's status as a non-Indian necessarily is a jurisdictional element. And like any other element, the government has a burden to prove it beyond a reasonable doubt. Because the government failed to do so at trial in this case, this court should reverse Mr. Haggerty's conviction and remand with instructions to enter a judgment of acquittal.
Before you go down the sort of the intricacies of jurisdictional element, sufficiency of proof, I have a little difficulty knowing how we get at this in any way other than on habeas alleging ineffectiveness of prior counsel. In other words, this defect, if it is one, was apparent on the face of the indictment. So my first thought would be you'd waive it if you didn't file a Rule 12 objection. Then you get to trial and there's no objection on this. Right. In other words, this issue was never brought to the attention of the district court, and there were multiple opportunities to do so. I admit it's a very intriguing, difficult issue, but I'm wondering how could it possibly be that we look at this de novo when the district court, even at a Rule 33 new trial motion, wasn't given an opportunity? And the last thing, because I asked long questions, is isn't it true that prior counsel actually used his admission of guilt to get successfully 3 points of acceptance of responsibility?
All right, well, let me unpack that. I'll begin with the last one first.
Okay. There's
precedent. I don't have it off the top of my head, but I handled a case years ago involving this very issue. What happens after a conviction during the pre-sentence investigation and a PSR at sentencing is utterly irrelevant for purposes of Jackson versus Virginia sufficiency analysis.
Yeah, that makes sense. I think you're right.
Sentencing is irrelevant. What matters up until happened to the moment before the conviction. So other points. So this is
it only would be irrelevant if we're looking at this under plain error, which I admit it's a stipulated bench trial and they're squirrely. But if we look at this under plain error, what happened at sentencing is relevant. In other words, at the PSR where he says he doesn't describe his race as Indian, we could consider that.
I respectfully disagree, but because it's a sufficiency of the evidence issue. Let me turn to the first couple of questions. So this is an element of the offense. It is a jurisdictional element, but it is nonetheless an element. It is analogous to proof that a bank is FDIC insured, which there's definitely case law saying that's an element, and if the government doesn't prove it, the defendant gets a judgment of acquittal. So this is not, it's jurisdictional, absolutely, but it's a jurisdictional element. So yes, there could have been a challenge to the indictment, but the Supreme Court held in Cotton and subsequent other cases that a missing element in an indictment does no longer guts the jurisdiction of a federal court. In fact, if a defendant doesn't object to a missing element in an indictment, it's subject to plain error review on appeal. So we're not talking about a case that was jurisdictionally deficient and that should have been dismissed because it was sua sponte, because it was missing an element in the indictment. We're not challenging the indictment on appeal. We're challenging the sufficiency of the jurisdictional element.
So maybe you went on plain error, but I have the exact same concerns that Judge Higginson does. I don't understand how you get de novo review. So maybe what I hear you saying is that maybe you went under plain error, but are we conceding that plain error applies?
Oh, no, absolutely not.
So help me understand how you can possibly come and talk to us about a missing element and sufficiency of the evidence, as you just said, without ever telling the district court at any stage.
Beginning in, I believe, 1960, this court held, I think it was Hall, it's in the briefs, and in numerous subsequent decisions, this court has held in precedent that is applicable to, in this case, that if there is a bench trial as opposed to a jury trial, the mere entry of a not guilty plea serves the function as a Rule 29 motion at a jury trial.
And how is that? Help me understand, why would there be a different standard of moving for an acquittal, for judgment of acquittal, in a jury trial and a bench trial? Well, I'm not disagreeing that we've said it. I'm curious, why would that be true?
Well, I think the reasoning is actually discussed in some of the earlier cases. The subsequent cases just cite the earlier cases without any sort of analysis. But I believe if you go back and look at Hall, again in the 60s, but nonetheless been reaffirmed repeatedly until quite recently. I believe the reasoning is a district court is not just the trial judge, but also the fact finder, and that the district court is in the position to, make the decisions about sufficiency of the evidence without having to have an argument.
But that would be true in a jury trial. In a jury trial, the whole reason you move under Rule 29 is you say to the district court, as a matter of law, there's a missing element, there's insufficient evidence on this element, please enter a judgment of acquittal. And if you don't do that, you can't come to us and complain about it. Well, so I don't understand why it would be true. In fact, I would think it would be more true in a bench trial because you don't have to have the jury there to deal with any of this.
Well, the bottom line, Your Honor, is that there are numerous published decisions of the Fifth Circuit saying that you do not have to articulate any specific grounds about insufficiency of the evidence to be able to receive the exact kind of review on appeal that you would receive if it had been a jury trial with a specifically articulated Rule 29 motion. So
let me ask it this way. So we're talking about published decisions. So Puckett, Supreme Court decision, 2009, it says the only way you preserve error is Rule 51. That's the only way. Our decision in Delgado, which is en banc and would control over any panel decision that you're talking about that precedes it, says the only way, 2012, en banc 2012 decision, says the only way that you can preserve a sufficiency of the evidence argument is through Rule 29 or an objection of error under Rule 51. Now, admittedly, Delgado's a jury trial. It's not a bench trial, but it doesn't make this distinction. It just straight up says, this is the way you do it. If you want to preserve error, Rule 51 gives you all of the instruments for doing it. If you want to move for judgment of acquittal, Rule 29 gives you all the reasons for doing it. And Rule 29 doesn't say anything at all about the distinction between bench trials and jury trials.
Well, Your Honor, there are numerous modern decisions. I don't have the specific ones in front of me in relation to the case you just mentioned, but this court has never questioned the proposition that at a bench trial, the mere entry of a not guilty plea is sufficient to preserve for de novo review of the Jackson versus Virginia issue on appeal.
Can I ask you this question? Because I find it so odd. How in the world can you enter a not guilty plea before any evidence is entered? And then that would preserve an objection to the sufficiency of the evidence that has not been offered.
Your Honor, I am again going to rely upon numerous published decisions of this court that has so held.
Can you think of one rational justification for the rule? Justification?
I would need time to go back and consider those issues. This is not something that counsel for the government has raised. So,
do you agree with us that the government cannot concede or waive the standard of review? We have multiple published decisions that say that.
The government cannot. Well, the court can sua sponte apply whatever standard of review it believes is appropriate. I agree with that.
Yeah.
But that's different from the issue of whether this panel is bound by prior panel precedent in bench trials.
Exactly. I'm just curious if you can think of a single justification for it. I take it the answer is no.
Well, I guess a judge is aware of the law, just like counsel is aware of the law. And if the law is each and every element of the offense has to be proved beyond a reasonable doubt, and presumably a district court is aware of case law of the Supreme Court concerning jurisdictional elements. And but if I could proceed to the merits of the issue. In terms of whether this is plain error review or preserved de novo review, we win either way because the error is absolutely plain. There are Supreme Court decisions going back to the 1800s all the way through 1990 that clearly hold, unquestionably hold, the second sentence of 1152 is a jurisdictional limit. A defendant has no burden to disprove subject matter jurisdiction in a case. That's absolutely axiomatic. The government has the burden to prove jurisdiction. Congress put it in the form of the second sentence. But
so on that theory, would the government also in every one of these trials have to negate that there wasn't tribal punishment and there isn't a treaty exception? Those other exceptions built into the second paragraph, those are all elements the government's got to negate beyond a reasonable doubt?
Under the Supreme Court's description of the second sentence of 1152, yes, Your Honor. We're not arguing that. We're focusing on the interracial aspect of it. So,
okay, but even if we accept that this is a sufficiency, and I really have difficulty, I don't think you've lost it. I think there may have been a tactical reason, and perhaps prior counsel has to answer for that in habeas, but I have difficulty addressing this. But let's assume you're right. It's a sufficiency question that somehow was preserved de novo. Can't the court have made a fair inference from his description as a white male, along with his tweets or whatever they were, sort of the extraordinary hostility to Indians? Isn't from those pieces of evidence, couldn't a reasonable fact finder have inferred that he isn't Indian himself?
Absolutely not. It's not whether you're white or not.
No, I'm focused more on his tweets or whatever he wrote. He clearly was detaching himself aggressively and antagonistically from Native Americans.
Well, I think that's a slippery slope, Your Honor, to go down the path that a person who articulates animus towards a particular racial or ethnic group can be deemed automatically by law not to be a member.
Well, I'm not saying by law. I'm just saying, isn't there an inference? Once you attack sufficiency, we draw all inferences in favor of the fact finder. It's an inference that could be drawn.
Not beyond a reasonable doubt. No rational fact finder could find beyond a reasonable doubt that a person who expresses racial animus or ethnic animus towards one group is proved beyond a reasonable doubt not to be a member of that group. Since 1994.
What sort of additional evidence would you require?
I can tell you a very easy way. The government's making a big deal out of how difficult this would be. There is a very, very easy way the government could prove a person is a non-Indian. Give them a DNA test, subpoena their blood.
What?
Yes. We do this all the time, Your Honor. There are grand jury subpoenas and trial jury subpoenas for people's DNA. We know there are DNA tests that can prove whether a person has Native American blood. A certain famous senator recently took one. This is not.
Would that blood have been enough? It's my understanding that was 1/64th or something. I could be a little off, but would her blood have been enough?
Well, there's an open question about how much is. The case law that I've read, I've seen as little as 1/8, but the language used in case law is any quantum of Indian blood. So if the government were to subpoena, as they are allowed to do, they do it all the time. DNA subpoenas happen all the time. If they subpoenaed a defendant's DNA, and by the way, you don't even have to do it blood, so you could just do a buccal swab. People do this all the time. If that determined there was no quantum of Native American blood, then the person cannot be an Indian, and they are by definition a non-Indian, even if
do you have a single case anywhere in the country for this proposition?
For which proposition, Your Honor?
This DNA idea that if this is in your brief, I missed it.
No, it's not in our brief. I'm responding to a question, Your Honor.
Okay, I'm just curious. You brought it up, so I'm curious if there's a source for it.
Well, there's certainly sources in law for taking DNA samples of suspects. We do it all the time. And I see no reason why taking the DNA of a suspect.
No, I think Judge Oldham is asking, the Title 18 is packed full of status crimes. Do you have a single case where that status crime has been proven through a subpoena getting a defendant's DNA?
No, but there are cases out there where there has been testimony, medical testimony, that the person's blood is or is not a certain percent Indian. I'm positive there are those cases, whether they use.
Well, your time's up. Why doesn't McKelvey control? Why isn't this an affirmative defense?
Because of Cook. McKelvey is not about jurisdictional elements. Cook says that if an ingredient of a crime cannot be, if you can't have an indictment without an ingredient of a crime being pled in it, and it cannot be an affirmative defense. even if it appears in some separate sentence. This is a jurisdictional issue, as I noted at the outset. You can't put the jurisdiction to, you can't force a defendant to negate jurisdiction. The government has the burden to prove jurisdiction.
So for you to prevail, we've got to say that is it the Ninth Circuit, the Hester case is wrong?
Absolutely wrong. They never cited Cook. Look at all the Ninth Circuit precedent discussing the issue. None cite Cook. The en banc 10th Circuit in Prentice, they note that Cook trumps McKelvey. This court in English noted the relationship between McKelvey and Cook. This is not like the other cases the government has cited. This goes to jurisdiction. That's what makes it so different. This is not and it's jurisdiction that is very important because it's the sovereigns of the tribal government, the state government, and this is federalism. The element is necessary to allow the federal government to be very careful in exercising jurisdiction as opposed to letting the states or the tribal governments exercise that jurisdiction. It's a jurisdictional element. The government has the burden to prove beyond a reasonable doubt. They could have proven it. They didn't. Whiteness is not, there's no white Indian racial binary anymore. Since 1994, Congress has said Indian or non-Indian in Chapter 54.
Okay, thank you. You've saved time for rebuttal. All right, Mr. Gupta.
May it please the court, Neeraj Gupta for the United States. This court should follow its rule in Santos Riviera, which uses the same rule as the Ninth Circuit and the Eighth Circuit, that an exception in the second paragraph of 1152 is an affirmative defense and not an element of the crime. Santos Riviera addresses or analyzes a statute very similar to 1152. Santos Riviera is...
before you get into that, why is the government must, I mean, it's a very interesting case, but you must have thought through the whole standard review or procedural default issue, and you haven't presented that to us, and it's very concerning to me. I'd love your insights now.
I took Rosas, Fuentes, and Hall for what they were worth, and they stated that in a bench trial, the sufficiency of the evidence review is that they don't waive that claim on appeal, even if they didn't object at trial. And I'm not sure why that rule exists. In this particular case, it's a little bit interesting. I'm not sure if it's an answer to your question of why that rule exists, but there was never an announcement of what the elements of this case were. At a jury trial, there would be jury instructions that would lay out what the elements are. Here, the parties never agreed to what the elements are, and the court never announced what the elements are.
So the challenge here, and I've seen this before, and the federal criminal rules don't really deal with, it's not just the problem of a bench trial. And I admit our law is a little unusual there. I don't quite understand it. Maybe Judge Oldham's right that Supreme Court and en banc law clear it up. But the real challenge is also that a stipulated trial, because what's going on there is everyone's thinking it's an equivalent of a guilty plea, but it really isn't. Right? A stipulated trial is still challenging the sufficiency of the evidence. And here, so you agree the indictment doesn't describe him as non-Indian, and Exhibit 1, which is all the evidence we've got, doesn't explicitly state it on its face. Correct. So that's why you've reduced your argument to, well, it is de novo review, but we claim it's an affirmative defense.
I don't think it's de novo review. The case
so it's plain error review. What's your best case for that? Because I would be sympathetic to that, but I'm curious what the authority is for that.
I think it's somewhere in between de novo and plain error. It's the deferential review that's described in Jackson v. Virginia, where this court is highly deferential to the verdict and views the facts and in the light most favorable to the guilty verdict.
All right, go on with the argument.
Okay, so. This court the government asked this court to use the analysis from Santos Riviera. Santos Riviera is cited in the brief, and I'd just like to emphasize what it holds. It analyzes a case very similar to 1152. It analyzes the hostage-taking statute, 18 U.S.C. 1203, which criminalizes international hostage-taking. And the second paragraph of the hostage-taking statute creates exceptions to the international reach of it based on the status of the victim and the defendant. It's very similar to 1152. In this case, this court used the McKelvey analysis to say that an exception in the second paragraph was an affirmative defense and not an element of the crime. That was the same analysis that was used in the Ninth Circuit, and that was the same analysis that was used in the Eighth Circuit, both in analyzing 1152, and we would ask this court to do the same.
Okay, but backing up, counsel opposite is saying this is jurisdictional to even have the statute. What is your response to that? That we couldn't even have the statute if they didn't have this element?
I think the jurisdiction, the word jurisdiction is being used in multiple ways during that argument. And I'd just like to clear up what jurisdiction means here. There's two kinds of jurisdiction. There's jurisdiction as it's used in Indian country, which is which law enforcement body, which sovereign can prosecute somebody, whether it's the federal government or the state government or the tribe. And then there's the separate matter of subject matter jurisdiction. And that's not an issue in this case. Nobody's ever challenged subject matter jurisdiction. There's a federal crime, 18 U.S.C. 1363. There was an indictment for that crime. And under 18 U.S.C. 3231, the district court had subject matter jurisdiction to hear that case and decide whether all the elements are there and whether the person is guilty.
But there has to be, I mean, as you know, the federal government can't just pass statutes that are untethered to interstate commerce, international commerce, relationship with Indian tribes. I mean, there has to be something. They can't just say my two neighbors on the driveway can't fight with each other here in Texas. Okay, there's nothing international, interstate, anything to tether it to the federal Constitution and federal law. So I think maybe I'm misunderstanding Mr. Newton's argument, but I'm understanding him to say to even get to this statute, you have to have this Indian versus non-Indian piece. So can you...
The jurisdictional component that you're asking for is in 1152, which says that when this happens in Indian country, then 1163 is implicated. The federal enclave law applies when this happens in Indian country. So the jurisdictional element that would need to be proven at trial is that the crime occurred in Indian country. It would be a matter of fact for the fact finder to decide that a crime occurred in this geographic area, and the judge, as a matter of law, would find that this geographic area is Indian country.
It's pretty settled Supreme Court law that the status of the victim is an essential element, right?
No.
No?
No, I think that we tried to address that in our brief.
I thought Lucas and Smith, I guess I'm wondering, you don't agree with that? Okay, well, because if it were, then it would be odd to say that the status of the defendant isn't an essential element, but the status of the victim is.
I don't think that's the right analysis. The question under 1152 is whether this is an Indian on Indian crime. That's the exception, Indian on Indian crime. And what's happening in Lucas and Smith is that they're analyzing the sufficiency of a case where the defendant has raised an issue. And then the appellate court is saying, did the government overcome beyond a reasonable doubt this claim that the exception applies? And it's nothing to do with the status of the victim or the status of the defendant, as if each of these are separate things that are separate elements. The issue is whether this is Indian on Indian crime. That's the exception in 1152.
Okay.
So
if we were to say that it was an essential element, do you lose, or on sufficiency review, is there or not?
I think it would be difficult. The court would have to make an inference that, as you described, that the district court analyzed this question and decided beyond a reasonable doubt that this person was a non-Indian. and that's default standard to meet.
Okay, so then, I mean, I appreciate your candor. So then, for under your analysis, to win, to affirm, you've got to, we would have to say that the en banc 10th Circuit was wrong in Prentice?
That's right, and I'd like to talk about why. So the Prentice, this court should reject Prentice, but this court doesn't have to reject the Supreme Court case that Prentice is based on. That Supreme Court case is U.S. v. Cook, and Prentice misapplies U.S. v. Cook, and so does appellant and appellant's argument. This is on page 980 of the Prentice decision. U.S. v. Cook is about the language of the statute. It's about the language. Can the language of the exception be removed from the statute? And this is what's left contain the ingredients of the offense, and does it not make reference to the removed language? It's about the language of the statute. And the Prentice in page 980 and in the appellant in their argument talks about the importance of the exception, not the language of the exception, but the importance of the exception. They say, well, this is an important exception, so therefore it's an element. That's how they applied Cook. And we're asking this court not to reject Cook, but to not apply Cook that way. If you look at 1152, it's 2 paragraphs. The first paragraph says, except as otherwise expressly provided by law, federal enclave law applies in Indian country. And then there are some exceptions. And if you remove those exceptions, the first part of the paragraph doesn't make reference to those exceptions. When it says except as otherwise provided by law, there are other exceptions in Chapter 53, most notably 1162, which carves out 6 states from 1152. So we think the best analysis is McKelvey. And this court has already applied McKelvey in Santos Riviera, and to a statute that's very similar to 1152, where the exception was in a separate paragraph. It was based on the status of the defendant and the victim, and it was held to be an affirmative defense and not an element of the crime. The Ninth Circuit has reasoned the same. The Eighth Circuit has reasoned the same way in Webster, although to a different exception. And we would ask this court to do the same and reject the application of Cook in Prentice without necessarily rejecting Cook itself.
Well, if that's all you were going to say on that, I just had one question on the sentencing issue.
Sure.
Often, I mean, it's an unusual crime, and therefore it's an unusual guideline enhancement. It is whatever the 3 things there are. The value equals the cost, the whatever the 3. And as I read the record here, no one was quite sure how to assess that, and therefore there was a phone call to the commission in the record. It seems like that's fine. That happens all the time. But then there was a reference in the sentencing proceeding that it then went to mediation. Can you explain what that was about?
No, I don't know the facts of that, actually. I didn't understand. I think that the sentencing guidelines state in the guidelines, by the plain text of the guidelines and the notes to the guidelines, that what matters here is value, not loss. And right. I think that appellants concede that, yeah. And on the reply say, well, that leads to an absurd result. And that's a matter of
studying what happened here, and it sounds like the commission came back and said, we think it's all 3 together aggregated. But obviously the district court didn't do that here.
That's right.
So the government's position is you can choose, but then it was what I just didn't understand. I'd never seen it. There was a reference to mediation, but maybe opposing counsel will have a recollection. Doesn't really matter. Your position is that given a cultural artifact, a district court has discretion to pick any one of the 3?
Or what the district court is supposed to do is value the cultural heritage resource. And there are 3 possible ways of valuing it, and including combining them. It's the district court's decision to try to come up with a value. And you can imagine things being damaged and trying to come up with a value where you would have to combine the restoration cost and other values and try to figure out what the value of it is. Here, it's not so complicated. The value of it is what they bought it for 3 months earlier. Okay. And then the argument is that that's an absurd result, which is an argument that was made at sentencing, that there should be a variance and a departure and the district court rejected that. And there's been no argument that that sentence was substantively unreasonable. I'd like to talk about the stakes of this case here. The appellant has been arguing, or appellant argued, that this is about tribal sovereignty. If you read the sentencing hearing on page 139, they introduce the police chief of the tribe who came to the sentencing hearing, who helped solve the case. He wasn't allowed to prosecute this case. This case isn't about protecting tribal sovereignty. The only law enforcement entity that could prosecute this case was the federal government. This is a non-Indian committing a crime against an Indian in Indian country. So the only way to prosecute this is through 1152. And adding extra burdens to the government under 1152 does nothing to protect the tribes. And I'd like to talk a little bit about that burden. The cases that are helpful to read are cited in the brief from the Ninth Circuit, Bruce and Riza Ramos. And both of them lay out what the process is of proving or disproving that somebody is an Indian. It's not just that they are enrolled from one of the 574 federally recognized tribes. The government doesn't merely have to disprove that, but they could also be affiliated or recognized by the tribe in some way and still be considered Indian for the purposes of criminal jurisdiction or for the purpose for fitting under 1152. They could be, in Bruce, the person wasn't enrolled, but participated in religious ceremonies. So the government somehow has to disprove that they're not affiliated with or associated socially or religiously with a tribe. This isn't a burden that the government can really do. It's a much more practical burden and a fair one for the defendant to make a claim that they are or are not Indian, and then for the government to investigate that claim.
So you disagree that the blood sampling, however we analyze that, would be sufficient anyway?
Well, it's a two-part test for somebody to prove that they're Indian. The first test, this is from the Supreme Court Rogers case, 45 U.S. 567, and then it's been cited by a number of other cases. And I think the clearest cases are those Ninth Circuit cases, Riza Ramos and Bruce. So the defendant or somebody claiming to be an Indian has to prove two things. That they have some quantum of blood, that they have an ancestor who's Indian, and two, that they're affiliated with one of the 574 federally recognized tribes. So the government can disprove that by disproving either one of those two steps, one of those two parts. Now, the 10th Circuit, the Prentice decision is from 2001, and I'm not aware of the 10th Circuit doing any DNA tests to disprove that somebody is an Indian. I'm not quite sure how that would work. It doesn't really seem feasible for a bunch of reasons. And I think the way the 10th Circuit has proven that somebody is a non-Indian is by interviewing them and having them admit that they're a non-Indian. But otherwise, it's a pretty difficult burden to prove that somebody isn't affiliated with a tribe in some way. And that was the Bruce case, where the person came forward with this information that they were participating in tribal religious ceremonies. Now, the government has no way of knowing that. The government can't affirmatively disprove this as part of their case.
Prior counsel didn't want to do a conditional plea because he wanted to attack the Constitution and the vagueness aspect, right?
I'm not sure. They did.
The lesson here is these stipulated bench trials, they always lead to new issues on appeal.
I agree.
And the way the system is designed is a conditional plea, where the district court then addresses it, makes a ruling, and then it all goes up like that. But
I'm not sure why there was a stipulated bench trial here. I think the defendant has the right to waive a jury trial. That's one of the defendant's decisions that they're allowed to make. And then,
but doesn't the government have to consent? Maybe I'm wrong.
I'm not sure.
Doesn't matter. Okay, I'm going off on a frolic.
And then then the stipulations happened.
Okay.
Any further arguments?
I think throughout their brief, the appellant discusses John and Westmoreland, and the government just asked the court to look at those cases. They don't stand for what appellant is claiming they do. John was a decision in the Fifth Circuit that an indictment and conviction under 1153 could be upheld under 1152. It wasn't a case that laid out extra elements for 1152. It's the opposite. And Westmoreland, we discussed it in our brief. It's a Supreme Court case that discussed whether the government needed to prove that, or had sufficiently proven, or had properly alleged that somebody was a non-Indian, and decided that it didn't matter that it was a harmless defect because it hadn't been raised before the verdict. So that's not a decision that supports the appellant's argument that this is something that the government needs to affirmatively prove. And in fact, it suggests that it's an affirmative defense that the defendant has to raise.
Okay.
If there's nothing else, then we'll rest on the briefs and ask the court to confirm the sentence and the conviction. Thank you.
Thank you very much. All right. Mr. Newton, you reserve time for rebuttal?
Yes, Your Honor. I have several points I want to discuss in rebuttal, but I do feel it's necessary to raise one issue in response to Judge Oldham's questions about the Hall case and all the other cases that, why should that rule be followed in the future? I think it's very important to note the Supreme Court is held in closely analogous circumstances that when the procedural default doctrine changes somehow in a jurisdiction, you can't retroactively apply it.
And I'm not saying that you retroactively apply anything. I'm asking you, Puckett and Delgado and Rule 51 all specifically tell you how to preserve error and this exact error. And I'm just trying to figure out why it is that your argument seems to hinge on us not reading Rule 51. Rule 51 literally says a party may preserve a claim of error by informing the court when the court ruling or order is made or sought of the action the party wishes the court to take. And the only thing I've heard from you is that it is sufficient to say, Your Honor, the evidence is insufficient. And the judge goes, well, we haven't heard any evidence yet. You're just pleading not guilty. The government hasn't offered anything. I haven't looked at the stipulated facts. We haven't done anything. And I don't understand. No one's talking about changing Rule 51. I'm just asking you, what would be the authority for ignoring the text of the rule, what the Supreme Court said in Puckett and what we said in Delgado en banc in 2012 prior to your trial?
These cases that I have cited have never been overruled in light of any language in Rule 51 or Delgado or Puckett. So my point simply is there was notice put out to the world that this is how the issue can be preserved, and it would be fundamentally unfair to retroactively require other things. So I want to address opposing counsel's argument about Santos.
But before you do, aren't I right that your client is fully protected if in fact he's Indian? There's no way you would overcome a Strickland habeas filing. If your client's Indian, he's going to win. There's no strategic reason here, right?
Your Honor, the issue is not.
No, I'm just asking. No, I'm just asking you that point. He will win on habeas if he's Indian. Do you have a thought on that?
I would suppose he would, but that doesn't matter in terms of the Jackson versus Virginia.
Well, I know that. I know. I'm just obviously. Okay, go ahead.
So Santos Rivera is not very similar to this case. The statute, the Hostage Taking Act, Section 1203A and B2, they do not concern jurisdiction. Yes, they do involve status, but they are not jurisdictional requirements. Those are simply policy choices Congress made. They do not go to jurisdiction, and therefore that case and any other cases that do not concern jurisdiction are inapposite here. They're a very different line of cases. So I also want to talk about Section 689, which the government of the Criminal Justice Resource Manual. The government's own guidance to its attorneys says these are jurisdictional issues. It's on the internet. You can pull it up. There's a chart, and the chart says Indian, non-Indian, Indian, Indian, non-Indian, Indian, and it says jurisdiction, no jurisdiction, jurisdiction, no jurisdiction. This is clearly a jurisdictional matter. Duro, Lucas, Westmoreland, all those cases make it abundantly clear. This court's decision in John in 1979, it's clearly a jurisdictional issue. You cannot put the burden on a defendant to negate jurisdiction. It is an element. It's a fundamental basic element. It would be a due process violation to shift the burden to the defendant to disprove fundamental jurisdiction. So it is a jurisdictional element. Jackson versus Virginia applies to jurisdictional elements such as the FDIC line, insurance line of cases where this court has held and other courts have held those are elements. This is quite simple. It may not be something that the court thinks is fair to the government, but the government ultimately has the burden to prove beyond a reasonable doubt each and every element, and they did not do so. Opposing counsel acknowledges that if this court applies Jackson versus Virginia in a preserved manner and deems this a jurisdictional element, counsel candidly conceded there is insufficient evidence. Whiteness is not enough. Pro-Christopher Columbus views are not enough. It's that simple. That's three simple propositions. It's a jurisdictional element. It was preserved by the entry of the not guilty plea, and there's insufficient evidence to prove it beyond a reasonable doubt under Jackson versus Virginia. It's that simple. Regarding the tribal sovereignty issue, whether in this instance counsel for the government believes it's disrespecting tribal sovereignty, that was not my point. My point is Congress created this jurisdictional element in all cases globally because it considers the jurisdiction of the federal government vis-a-vis the state governments, vis-a-vis tribal governments. That's why it's a jurisdictional element. And I thank you.
Okay, we thank you both for your arguments. This case is under submission and you all are excused.